Financial wellness. Reach out to them for advice at 855-DON-GINO. And now back to your hosts, Don Getling and Gino Franti.
Jump into the real estate piece of it.
Well, so one of the things that comes up a lot is how do we deal with real estate when we need to transfer it, whether it be at death or whenever during a person's lifetime. Under California law, you can only transfer real estate by operation of law. So if somebody passes away and there's a joint tenant, the surviving tenant automatically becomes the owner. Then there is by deed. So obviously in a normal sale transaction that you guys deal with, someone signs a deed over to the buyer and a transaction with an escrow happens and the new buyer takes over. And then when they're ready to sell, the same process happens again. With respect to a trust, in the context of a trust, the reason that a trust helps a family avoid probate is because there's a deed that transfers the property. It's called a trust transfer deed. It transfers the property from the owners, the buyers that you may have helped, into their trust. And then when they pass away, the trust doesn't pass away with them. And so therefore it avoids probate. That's one of the benefits of the trust. And that's pursuant to California law. That is a valid way of avoiding what's known as a probate. The other way of transferring property in California is through a probate proceeding, which is a court proceeding whereby essentially the court determines who the heirs of a particular decedent, of the person who's passed away are, and in what distribution scheme should their property be distributed. Now, the person who's passed away may have a will, so that may dictate how these monies are distributed. But if they don't have a will, then the laws of California intestate succession apply, which basically is for lack of a better way of putting it, it's kind of think about your bloodline. Who's closest in bloodline to you? And obviously your direct descendants, your children are the first, and your grandchildren, great-grandchildren. The law sort of favoring... The law favors the idea that most people want their children to be their beneficiaries. And then it goes back up to parents and then to siblings, and basically just it's known as a consanguinity chart, and that's the way that the intestate succession scheme works. Before if they can't find anybody, an ex-spouse could potentially be an heir way down the road. And then it could go to the state of California if no heirs can be found.
Which is actually more common than people think.
It is. It's known as a sheeting to the state of California, and it happens way more commonly than you would like to think. So the reason I bring this up is because California actually has a bill right now on the assembly floor to create a new type of deed called it's going to be a revocable transfer on death deed. And essentially what that means is that you would put your beneficiaries in your deed. So it might say Don Getling, a married man, as his sole and separate property, and you give everything to Cindy in the deed.
Right.
And by operation of law, so just like in a joint tenancy situation, by operation of law, when you pass, that property would pass to Cindy. Now, this is wonderful for people who don't have the funds to do estate plans. It could be potentially huge for a lot of people. It's not the perfect solution. It definitely discounts a lot of important things that we consider in an estate plan, but it's currently on the assembly floor, and so it should be really interesting to see what happens with that and how estate planning practice changes a little bit. I think it will pass. I don't know for sure, but it made it through. Yeah.
Yeah, I don't see why not.
20 other states do this. It's not uncommon, and it hasn't changed estate planning practice. I mean, at the end of the day, estate planning is not just about who gets your property. There's a lot of other issues that we consider.
Right.
Just like a minute ago, we were talking about the powers of attorney and the advanced health care directives. Your house is one component of you, but just like you're multifaceted and you're just yourself, your property and your person and how those things have to be dealt with in certain situations also are multifaceted and need a lot of planning. And particularly this transfer on death deed would do no good if you only have minor children. Minors cannot be owners of real estate unless they have special court orders. It's very, very, very rare. And so therefore, that's not a great tool to use if you just have minors, because it won't work.
That's a good point, right.
And plus, if you have minors, you need to think about guardians, and there's other things that have to be considered. So this new deed, if it passes, I think it will, should be interesting. I think it's going to be great for some families who really, really don't have the ability financially in any
Capacity
reality.
to be able to get a trust.
Exactly.
Yeah.
So I think it could be great, but it should be
I like
interesting.
your example, Gino. Good, better, best.
Yeah, I mean, that's kind of what it is, right? I mean, what we have right now, our deed system is, I don't even know if I want to call it good, because it's not even good, right?
No.
It's a little less than good.
Yes.
Our deed system is complicated. There's very little places to get educated in the middle of a real estate transaction. None of us are licensed, except for you here, Lisa. But in the real estate world, none of us are licensed to talk about it. So we hand them a sheet, and we say, "Here, you read the sheet, and good luck."
Yep.
You know, and if you want any more information, please reach out to an attorney. But it's like what we talked about earlier. It has to be more than that. We have to hold a responsibility to make sure our clients call you, because the reality is when you just give them a sheet, they don't have all the information necessary. So what we have right now is good. This new deed, if it passes, that'd be better. It'd give people a little more options.
It certainly will avoid probate, which is a positive in my mind.
Sure.
Oh, sure.
So
So
I just
because a
hope-
will, people don't realize a will is a ticket to probate.
pretty much, if there's real estate or assets that exceed 150,000, it's a ticket to probate.
Yeah.
All
And
right.
remember, that's on gross assets. So if your house is worth $500,000, but you owe $500,000, guess what? You're still going to probate.
And
There
it's
you
still going to cost the full amount, even though there's zero equity in it.
Yeah, I hate it when that happens. Again, if you just tuned in, you're here on the Don and Gino Real Estate and Finance Show. We're here with Lisa Odom with McDowell Odom LLP, attorneys at law, talking about ways to protect you and your family and things you don't know. Every time we have Lisa on the show, and this is something we have learned, and I wish we're probably not going to be able to get to topic number 2, because there's so many areas that you help regarding trust and real estate issues and business issues, because you're helping some of our new business transaction as well, and setting up a partnership and all that, which is really cool that you also do that. But I don't want to get off topic, because you have this, this new potential way to be able to hand over your property through just a new deed, basically. And it probably will pass. But the thing Gino and I have learned, and this is what we want to relay to you, because we only have a little over a minute here, is that there's so many things you don't know or don't think about in regard to your family. God forbid something happens to you or your spouse. And as we've gone through the process with you, Lisa, you brought up so many things as we're going through page after page. At first you look at it and you're like, oh, this is overwhelming. But then you're like, oh, my gosh, I'm so glad that is in there. I never even thought about, what do we do with our animals? What do we do with this? Or what if we're both in the car when that happens? And who gets this? Or what if that? I mean, there's so many things that the entire trust goes through, and you guys are really good about walking us through. You were very patient. You don't just say, yeah, you're on your own, because you can do that online. That's a no-no. Trust me. You need somebody
This is not a do-it-yourself situation, please.
This is one of the most important decisions you will ever do in the rest of your life, and to protect you and your family and your assets you've worked so darn hard for. Don't lose your assets.
Exactly.
I mean, what you really want to make sure is that, you like that, the protect your assets.
Protect your assets.
Yeah. The thing you want to make sure is that by having an estate plan in place, you have peace of mind, too. I mean, that's the other thing as well. You know that if something were to happen to you, you're good to go. Everything's fine. And that gives you peace of mind every day. And hopefully with less stress, you could live a little longer.
Yeah. So if you want peace of mind and live a little longer, reach out to Lisa Odom and McDowell Odom LLP. How can they get a hold of you, Lisa?
Call our office at 661-449-9630.
What about your website? Good website.
Oh, yes. Visit us online at www.mcdowellodom.com.
Very nice. Always great having you on the show, Lisa.
Thanks for
Great
having
information.
me.
I hope you were paying attention. And you can always get our shows by going to donandgino.com, DonandGino. We record them. There's a YouTube channel there. Get it all. And make sure you tune in every Saturday, 9 a.m. to 10 a.m. Thanks for joining us. Have a beautiful Saturday, and be good humans.